Act Number 2031. February 3, 1911. The Negotiable Instruments Law. I. Form and Interpretation. Section 1. Form of negotiable instruments. An instrument to be negotiable must conform to the following requirements. A. It must be in writing and signed by the maker or drawer. B. Must contain an unconditional promise or order to pay a sum certain in money. C. Must be payable on demand, or at a fixed or determinable future time. D. Must be payable to order or to bearer, and E. Where the instrument is addressed to a drawee, he must be named or otherwise indicated therein with reasonable certainty. Sector 2. What constitutes certainty as to sum? The sum payable is a sum certain within the meaning of this act, although it is to be paid A. With interest, or B. By stated installments, or C. By stated installments, with a provision that, upon default in payment of any installment or of interest, the whole shall become due, or D. With exchange, whether at a fixed rate or at the current rate, or E. With costs of collection or an attorney's fee, in case payment shall not be made at maturity. Sector 3. When promise is unconditional. An unqualified order or promise to pay is unconditional within the meaning of this act though coupled with A. An indication of a particular fund out of which reimbursement is to be made or a particular account to be debited with the amount, or B. A statement of the transaction which gives rise to the instrument. But an order or promise to pay out of a particular fund is not unconditional. Sector 4. Determinable future time. What constitutes? An instrument is payable at a determinable future time, within the meaning of this act, which is expressed to be payable A. At a fixed period after date or site, or B. On or before a fixed or determinable future time specified therein, or C. On or at a fixed period after the occurrence of a specified event which is certain to happen, though the time of happening be uncertain. An instrument payable upon a contingency is not negotiable, and the happening of the event does not cure the defect. Sector 5. Additional provisions not affecting negotiability. An instrument which contains an order or promise to do any act in addition to the payment of money is not negotiable. But the negotiable character of an instrument otherwise negotiable is not affected by a provision which A. Authorizes the sale of collateral securities in case the instrument be not paid at maturity, or B. Authorizes a confession of judgment if the instrument be not paid at maturity, or C. Waives the benefit of any law intended for the advantage or protection of the obligor, or D. Gives the holder an election to require something to be done in lieu of payment of money. But nothing in this section shall validate any provision or stipulation otherwise illegal. Sector 6. Omissions. Seal. Particular money. The validity and negotiable character of an instrument are not affected by the fact that A. It is not dated, or B. Does not specify the value given, or that any value had been given therefor, or C. Does not specify the place where it is drawn, or the place where it is payable, or D. Bears a seal, or E. Designates a particular kind of current money in which payment is to be made. But nothing in this section shall alter or repeal any statute requiring in certain cases the nature of the consideration to be stated in the instrument. Sector 7. When payable on demand. An instrument is payable on demand A. When it is so expressed to be payable on demand, or at sight, or on presentation, or B. In which no time for payment is expressed. Where an instrument is issued, accepted, or endorsed when overdue, it is, as regards the person so issuing, accepting, or endorsing it, payable on demand. Sector 8. When payable to order. The instrument is payable to order where it is drawn payable to the order of a specified person or to him or his order. It may be drawn payable to the order of a payee who is not maker, drawer, or drawee, or b. the drawer or maker, or c. the drawee, or d. two or more payees jointly, or e. one or some of several payees, or f. the holder of an office for the time being. Where the instrument is payable to order, the payee must be named or otherwise indicated therein with reasonable certainty. Sector 9. When payable to bearer. The instrument is payable to bearer. A. When it is expressed to be so payable, or b. when it is payable to a person named therein or bearer, or c. when it is payable to the order of a fictitious or non-existing person, and such fact was known to the person making it so payable, or d. when the name of the payee does not purport to be the name of any person, or e. when the only or last endorsement is an endorsement in blank. Sector 10. Terms when sufficient. The instrument need not follow the language of this Act, but any terms are sufficient which clearly indicate an intention to conform to the requirements hereof. Sector 11. Date, presumption as to. Where the instrument or an acceptance or any endorsement thereon is dated, such date is deemed prima facie to be the true date of the making, drawing, acceptance, or endorsement, as the case may be. Sector 12. Antedated and postdated. The instrument is not invalid for the reason only that it is antedated or postdated, provided this is not done for an illegal or fraudulent purpose. The person to whom an instrument so dated is delivered acquires the title thereto as of the date of delivery. Sector 13. When date may be inserted. Where an instrument expressed to be payable at a fixed period after date is issued undated, or where the acceptance of an instrument payable at a fixed period after sight is undated, any holder may insert therein the true date of issue or acceptance, and the instrument shall be payable accordingly. The insertion of a wrong date does not avoid the instrument in the hands of a subsequent holder in due course, but as to him, the date so inserted is to be regarded as the true date. Sector 14. Blanks, when may be filled. Where the instrument is wanting in any material particular, the person in possession thereof has a prima facie authority to complete it by filling up the blanks therein. And a signature on a blank paper delivered by the person making the signature in order that the paper may be converted into a negotiable instrument operates as a prima facie authority to fill it up as such for any amount. In order, however, that any such instrument, when completed, may be enforced against any person who became a party thereto prior to its completion, it must be filled up strictly in accordance with the authority given and within a reasonable time. But if any such instrument, after completion, is negotiated to a holder in due course, it is valid and effectual for all purposes in his hands, and he may enforce it as if it had been filled up strictly in accordance with the authority given and within a reasonable time.